Hello friends, in the series which we are doing on the history of India from 1750s to 1857, today we will talk about the evolution of law and colonial codes part 2. In the earlier discussion on the evolution of law and the colonial codes, we talked about the kind of changes which were brought about by the British when they came to India and when they settled in India. And we talked about the Regulating Act and the contribution of Warren Hastings, who was the governor, and then the way he presided over the kind of changes which came in the evolution of law. And at the same time, we also find that in the later part, especially in the 19th century, the various kinds of ideological trends, how they also contributed in bringing about the various kind of changes which came in the laws, the various kinds of charter acts which were initiated by the British beginning from 1793 onwards, where 20-year charter was given to the East India Company, and various kind of concessions which were being given to the East India Company over a period of time, they were also being taken away in the later charter acts with regard to the kind of monopoly rights which were exercised by the British in the Indian territories as well as China. So they were in a way taken away because there was a lot of pressure from the free trade lobby, which did not want that the East India Company should become more and more dominant. So we find that these kind of changes which came in the 19th century in the first half, they had some kind of a background in the 18th century as well. And the coming of the Regulating Act, which was the first act which was imposed on India by the East India Company, and thereafter we have the Pitt's India Act in 1784. And when you see the references, or what references you can use Thomas Metcalfe's Ideologies of the Raj, Shikhar Bandyopadhyay's From Policy to Partition, A History of Modern India, B.L. Grover, An Introduction to Modern India, NCERT and IGNOU material. So these are some of the readings apart from the other ones which you can refer when you are talking about the colonial codes in India, the kind of changes with regard to the laws which were initiated by the British. So as I told you that how ideologies, they played an important role, especially in the context of the Orientalism, in the context of evangelicalism, in the context of utilitarianism, and how British, they tried to use these ideological pressures so that they are able to in a way dominate India in every way. And the kind of changes which came with the Charter Acts, we see that the Charter Act of 1793, and which was introduced in India, which introduced this kind of a notion of a civil law, and which was enacted by a secular human organization and which was to be applied universally. And free traders, they became more powerful in the British politics, and they were seeking free entry to India. So the Charter Act of 1793 basically talks about the notion of a civil law, and how the idea of a secular human organization was also could be seen in this act, and how it had to be applied in a way, in a universal manner. It also talks about these kind of ideas. And as we see that industrial revolution which had been initiated in Britain, and the people, those who wanted to trade more and more with India, they wanted that how the primary products, or the products which are the unfinished products, or the agricultural products, they should be sent from India to Britain, and the finished products, they should go from Britain to India, so that in both ways the British, they are able to secure more and more money for themselves. So free traders, they wanted that the East India Company, they should not have any kind of a monopoly of the Indian trade, and on the other hand, East India Company was paying the British Parliament a huge sum of money, handsome money, so that they are able to in a way safeguard their privileges in India. And we see that over a period of time, the various kinds of charters which were initiated in India, for example the 1813 Charter Act, which was introduced by the British, it talked about the Christian missionaries and how they were being permitted to come to India. and they had to seek some kind of a license from the court of directors or the board of control, which court of directors and the board of control, they could provide any kind of a license to these missionaries, and they could come and settle in India. And initially we find that at Srirampur near Calcutta, these missionaries, they settled themselves. And we also find that how the monopoly of the East India Company, which was trading with India, that was also abolished apart from the tea, and how the monopoly of the East India Company with regard to China, it continued for 20 years. So that was the kind of change which came with the Charter Act of 1813. And this charter, when it was talking about the arrival of the Christian missionaries in India, then how these Christian missionaries they engaged themselves in the conversion of the Indians to Christianity. And the free traders lobby and the Christian missionaries, they had similar kind of objectives during this period. We find that the Christian missionaries, they also wanted that free traders, they should come to India, and they wanted that more and more British products they should be sold to India, so that the Indians, they are able to develop some kind of a taste for the British products. And at the same time, the ideas of Christianity, they should also will help the Indians to, in a way, reconcile themselves to the British ideas as well as the British products. So this kind of a change we see with the arrival of the Christian missionaries from 1813 onwards, when the Charter Act permits them to come to India. And we also find that in the later charters, when they came, for example, the Charter Act of 1833, when it was introduced in India, at that point of time, the kind of trade which the East India Company was engaged in with regard to China was also, in a way, their monopoly was taken away. So these were the kind of changes which came with regard to the Charter Acts. But before that, when we tend to see the various governor and the governor generals, those who ruled India in a way, we talked about Warren Hastings in our earlier lecture. And when we talk about Cornwallis, we can say that he, in a way, was thinking in terms of more and more Anglicization of the administration, and he believed that Indians, he had a very low opinion with regard to the character of the Indians, their ability and the integrity, and he considered them to be corrupt in nature. And that is how the higher posts in the administration and the army, they could not go to the Indians, they could not rise in the administration and army beyond a certain rank, and the command was always in the hands of the Europeans. So these kinds of ideas of prejudice and racialism, they lasted throughout the British rule in India. Not only Cornwallis, but other governor generals and viceroys, those who ruled India till 1947, they had these kinds of ideas of prejudice and racialism. And the various laws which were introduced in India by the British, they also smacked of these kinds of policies which were being followed by the British in India. And when we tend to understand these kinds of laws, that how the Code of 1793, which was introduced by Cornwallis at that point of time, so it set the rule of separating the revenue collection from the administration of civil justice as a safeguard for property rights against the abuse of power by the revenue officials and their agents. So this kind of a change which we find during this period, and the new system, it was also providing for a hierarchy of courts from the Jilla district and city courts to 4 provincial courts and Sadar Diwani Adalat with appellate jurisdiction. So these were the kind of changes which were brought about during this point of time. And we also find that when I was talking about the ideas of racialism, that how British, they considered themselves to be more superior in nature. So they felt that the courts, they were to be headed by the European judges with the provision for the appointment of the native commissioners. And we also find that the criminal justice system during this time with the Code of 1793 was it was completely overhauled, and the district magistrate complained to Cornwallis about the anomalies of the Islamic laws and corrupt practices at the criminal courts. So when these kinds of objections, these kinds of issues, they were being raised, then as I told you earlier that Cornwallis, he had a very bad opinion about the Indians, and he considered the Indians to be corrupt in nature. But at the same time we will realize that the way the payment of salaries which was made to the Indians, it was comparatively very, very low. When you tend to compare it with the Europeans were paid very, very highly, and at the same time even when they were being paid very highly, the Europeans, they were engaged in a lot of bribery and corruption. So this kind of prejudiced ideas, they could be seen during this point of time, and they believed that any aspect of administration at the highest levels could not be left to the Indians. So Indians, either in the framework of administration or in the framework of armies, they occupied the lowly positions. They were not given high positions by them. We also find during this period that the Fauzdari Adalats, they were being abolished, and they were replaced by the Court of Circuit, which was headed by the European judges, and the Sadar Nizamat Adalat was brought back to Calcutta, and it was placed directly under the supervision of the Governor General in Council. So these were the kind of changes which were brought about during this period. And we find that how, when you talk about the various kinds of codes, then the British born citizens, they were in a way given all sorts of exceptions, and the British born citizens or subjects, they were not covered by these kinds of codes, and they were to be covered by the jurisdiction of the Supreme Court at Calcutta. So this idea of racialism could be seen in this aspect as well. And if you see the entire judicial reforms which were initiated by the Cornwallis during this time, then one thing was very common, that how Indians, they had to be excluded from the entire system, and the system was authoritarian in nature, and system had that kind of a tone which was suggesting that it was racial in nature. So British, they considered themselves to be superior in nature. They felt that how Indians, they were to be excluded from any kind of a responsibility at the highest levels, and they could only be utilized at the lower levels, where they had to support the British in terms of decision making. So this kind of a prejudiced mind in a way was reflected when these kind of measures, they were being initiated at this point of time, and as later as well during the 19th century and the earlier 20th century as well, when British continued with such kind of laws. We also find that some kind of changes at the local levels and regional levels could be found when Thomas Munro, he insisted that and on his insistence, we find that the Court of Directors in 1814, they proposed a law or a different kind of a system for Madras, which included the provisions for the greater Indianization of system at the lower levels, at the village panchayats, districts, and the city courts, and the union of magisterial, revenue collection, and some judicial powers in the office of collector. So such kind of changes, they came at the regional level, and later Elphinstone, he extended it to Bombay in 1819. So we find that especially in the 19th century, the ideas which were perpetrated by the various kinds of ideological trends, which could also be seen during this time, and utilitarians and evangelicals, both of them, they wanted that the kind of reforms should be brought about in India, and the idea of improvement was in a way talked about, that how the Indian system could be improved, and they had to apply the British principles of justice and uniformity under a civil authority which was to be exercised by the British personnel. And that is how we see that certain laws like the abolition of sati, laws against the female infanticide, laws in favor of the widow remarriage. All these kinds of things they were being talked about, and British, they felt that they had to intervene, and Lord William Bentinck, who was the Governor General at that point of time, and who was highly influenced by the utilitarian ideals, and who believed that the India is to be governed by the rule of law, and this rule of law was to be introduced by the British, and thereafter such kind of interventions they were being made by the British. And we also find that some of the Indians like Raja Ram Mohan Roy, etc., they also talked about, they cited that how Indian scriptures, they were also against such kind of practices like sati which were being followed, and Indian scriptures, they were also not in favor of such kind of practices. When we talk about the kind of ideological trends, we find that Jeremy Bentham talked about the good laws and how the efficient and enlightened administration were the most effective agents of change, and the idea of rule of law was a necessary precondition for improvement. So we find that during this time the followers of Jeremy Bentham, who was talking about these laws, and how these people they were also talking about that how Indian society had to bring about this kind of a change, and the Indians, they were to be governed in such a way that British, they had to act like the efficient schoolmasters, and Indians they had to listen to these schoolmasters in such a way. And people like James Mill, they had these kind of ideas. They talked about the supremacy of the British, and talking about the idea of paternalism, where the efficient schoolmaster will bring about these kind of change. And as we talked about the various kinds of charter acts, that how the 1833 Charter Act, it talked about the evangelist position and the free trade merchant positions, and both of them, they were talking about the idea of assimilation and Anglicization, and how evangelist Charles Grant, he presided over the passage of the Charter Act of 1833, which abolished the East India Company's monopoly right over the Indian tea trade and trade with China. So we find that these kind of laws, they were trying to bring about this kind of a change, where more and more Anglicization takes place, and how Indians they become Anglicized in a manner that they in a way accept the British ideas, and they had to be assimilated assimilated in such a way to the British culture and British practices that they reconcile totally in that particular context. We also find that a law member was also added. T.B. Macaulay became the law member during this time, and how T.B. Macaulay or Thomas Babington Macaulay was also associated with the Education Minute during this particular period. And there was a controversy of the Anglicist and the Orientalist, where how the education was to be imparted to the Indians, and how people like Macaulay, they wanted to bring about this kind of a change in the Indian society, where the taste, opinion, morality and intellect of a European should in a way enter Indians, so that they are able to in a way relate with the British ideas. So they wanted to transform the Indians to such an extent that Indians, they remain Indians only in blood and color, and their taste, opinion, morality and intellect becomes more and more British in nature, so that British are able to sell their products to India. The British, they are able to bring about changes in the Indian society with these kind of ideas and propagation of the ideas of Christianity. So we find that some kind of issues during this particular period with regard to the codification of laws, that how these laws, they had to be codified, how a uniform judicial administration is to be created, and a civil authority throughout British India is to be created. But another important aspect was the issue of Indianization, that how the people, those who were Indians, how they are able to in a way in a way taken more and more into the administrative sphere. And we also find that during this point of time in 1833 talked about the Law Commission, and this Law Commission was talking about the codification of laws. And Thomas Babington Macaulay, who came as a law member, he was very instrumental in terms of the Law Commission and the codification of laws, and various other kinds of acts they were also being initiated after 1858 as well. As you can see on the screen, that how Macaulay completed the task of codification by 1837, and thereafter the Code of Civil Procedure in 1859, Indian Penal Code in 1860, Criminal Procedure Code in 1862. All these kinds of laws, they were being in a way introduced at that point of time. Scholars like Radhika Singha, she has talked about the new codes which sought to establish the universal principles of jurisprudence, which are based on a notion of indivisible sovereignty and its claims over an equal abstract and universal legal subjects. So these were the kind of ideas, these were the kind of the ideas which were being talked about by some of the scholars, that how British, they wanted to impose their laws in India. And we find that in many of the princely states, we do not find that these laws they were being initiated, because the princely rulers, they had their own laws, but British, they sent their agents in the form of the British resident, those who were in a way interfering in the various kinds of laws during this time. So we find that when you tend to understand these laws, then the justice became very expensive because of it, and a huge number of court cases, they started piling up, as you can see on the screen, and justice became inordinately delayed. And it was only the public side of law that upheld the idea of freeing individuals from the shackles of status. So when you tend to understand these kinds of effects, that how because of the coming of this kind of a judicial system, and because of the judicial system, we find that these kind of changes they came. And the Charter Act of 1853, where you find that it was not renewed for 20 years, and East India Company was permitted to keep the Indian possessions in the trust of Her Majesty, her heirs and successors, until Parliament shall otherwise provide, thus keeping access open for a future takeover. And this takeover takes place definitely when, after the revolt of 1857, we find that how the East India Company's rule ended, and how the British Crown, it becomes more dominant, and how British Crown takes over the rule which was earlier which was under the East India Company. So to end, I would like to say that all the laws in the context of the British, the kinds of charter acts, they always smacked off the idea of superiority and racialism, and British, they had their own ideas which they tried to show in the context of their ideological positions, and where their economic self-interest as well as the political expediency, it dominated. Thank you very much.